Good afternoon to all our attendees. I'm Jack Ferris, a director in Clifdeck Hoffmeyer, where I primarily render risk advisory and regulatory and dispute resolution services. Thank you for joining us for this live webinar event on virtual dispute resolution. I will be wearing two caps today, both being a presenter and a moderator for any questions that you may pose during the session. From a housekeeping perspective, I will just set out the following. The webinar is scheduled for 30 minutes. Each presenter will speak for about 16 minutes, with the balance of the time reserved to answer all questions raised during the session. As presenters present, feel free to pose questions under the Q&A tab. This is also a general discussion, so there will be no specific slides that will be used by each of the presenters. And also apologies for any background noise. We're all at home, might be dogs barking or other noises, so please, we apologize for that. In relation to the discussion, the Chapman House rules will be applicable. So the panel will be unpacking the use of technology in alternative dispute resolution, such as virtual arbitrations, whether domestic or international, and other alternative dispute resolution processes, such as virtual mediations or negotiations, and whether that would ultimately result in disputes being resolved fairly, expeditiously, and on a cost-effective basis for disputing parties. We will also be dealing with the oversight role of courts, in particular for arbitrations where arbitral awards are final, binding, and enforceable. And the important part of that is ultimately to ensure where you're running an arbitration that the parties to the arbitration are treated fairly and equally. So we will unpack that in a bit more detail. So our panel for this webinar is the following esteemed members of our legal profession. Honourable Justice David Untitled of the High Court of South Africa, Gauteng Division. Just one note for David or Justice Untitled in relation to his discussion. We will, after my presentation, allow questions after Justice Untilted's presentation, just to ensure that he is able to attend back to a virtual court hearing that he is scheduled for 2 o'clock. Then the next presenter will be Advocate Lindy Nkosi Thomas, Senior Counsel of the Johannesburg Bar, based at AFSA, Johannesburg Chambers. And then, but not least, is Julia Leroux. She is the registrar at AFSA International, and she will be unpacking what institutions like AFSA and AFSA International are doing in relation to virtual dispute resolution. So I will start with my portion of the session, just setting the scene for the discussion of all the other presenters. We are truly living in unprecedented times, with nearly 50% of the global population in lockdown to effectively deal with the spread of COVID-19. The global lockdowns have caused severe financial and economic hardship to businesses and ordinary people across the world, including in South Africa. I don't think there's one person that can say they're not directly or indirectly affected by COVID-19. What COVID-19 will also do is ultimately result in multiple disputes, issues like force majeure, hardship between parties, contracting parties, and potential delictual claims or claims against the state. That brings to the fore how courts, arbitral tribunals, and practitioners are adapting to the disruptive effect of COVID-19. The legal profession has not been a safe haven to COVID-19's disruptive effect, except for new disputes that will flow from the lockdowns caused by COVID-19. Existing disputes, whether arbitrations or trials or court applications, have been directly impacted by lockdowns and will continue to be impacted in the coming months, as we are all required to exercise social distancing to contribute to the flattening of the curve. So the big question: can virtual dispute resolution be the answer to ensure that in a time of social distancing, the show goes on? Does existing disputes that are resolved fairly, expeditiously, and cost-effective basis without the need for physical meetings between disputing parties, the arbitrators, the counsel, and so on? And would that be the catalyst for parties to insist that future disputes to be resolved on a virtual basis? We are truly at the precipice of a new era for dispute resolution, forced on us by a major disruptor, COVID-19. The choice has now been made for us, and we have to adapt to the new normal. although in relation to virtual dispute resolution, there has been a lot of talk and written work in relation to this prior to COVID-19. We have never been forced, as we now have, to actually be totally dependent on technology for the entire dispute resolution process. Interestingly, last week, I actually got an email from an opponent in an arbitration that I'm involved in, where I proposed certain procedural steps dealing with the pre-arbitration or pre-issues for an arbitration. And his response to me was very interesting, and I think it also sums up how most practitioners nowadays or still perceive technology. And his statement to me in his email was, as much as I dislike virtual realities and modern technology, I prefer pre-Christian modalities such as meet eye to eye and do the body language stuff. I can't see anything from a level 5 to level -5 that will ever take us back to normality. So essentially making the statement that we are in a new normal and we need to adapt to the change. And this was merely in relation to, as I mentioned, to pre-arbitration matters, to deal with appointment of arbitrators and so on. And that ultimately indicates the anxiety and fear that a lot of practitioners and institutions also have in relation to virtual dispute resolution. South African practitioners are not that different in terms of their anxiety than in other jurisdictions. In a recent article published by the Global Arbitration Review, where they summarize a statement made by one of the leading arbitrators, Janet Walker, a Canadian arbitrator and a professor of law, noted that very few arbitrators have had experience in full virtual hearings in which all rather than just one or two participants are taking part remotely. There's somewhat a familiarity where if you have one person on the other side who cannot be physically present, but it's a totally different scenario where you have to run the entire arbitration or process virtually. Even in where we sit in one city, like in Johannesburg, where parties cannot physically be together in one physical meeting room to conduct an arbitration. So it's truly changing the way that we need to approach the resolution of disputes and what mechanisms we can use to deal with that. So what do we mean by virtual dispute resolution actually? So it is essentially conducting the entire dispute resolution process using technology. This includes, but is not limited to, video, audio conferences, emails, online document sharing and storage facilities, including such other technologies necessary to ensure the effective resolution of a particular dispute, like virtual site inspections, where you need certain equipment to allow the arbitrator and counsel and other parties to actually virtually be on a particular site where another party is walking the ground. And the other thing is, so for mediation, there may be a bit more flexibility in how technology can be used. However, for arbitration, there's a bit more process and procedure that goes into it and ensures that parties to the proceedings are treated fairly and ultimately was able to effectively present their case to the arbitral tribunal. So for that process, what is contemplated? So we ultimately mean there's all pleadings prepared by parties are prepared electronically, served and filed electronically, electronic discovery bundles for documents for evidence purposes, bundles creating electronic repositories for the storage of documents where the accessibility to parties are easy, and also the restriction in some instances for parties to tamper with documents. We talk about virtual meetings with arbitrators and parties in relation to case management and all the incidentals that goes with an arbitration. We talk about virtual inspections in loco, say where you need to go to a particular mine or you need to go to a power station to inspect certain things. You send a neutral person to go to the site, but the other parties to the dispute needs to have all the relevant equipment necessary to actually virtually participate in that inspection in loco. Virtual hearings where witnesses and experts sit in different locations all over South Africa, or if it's an international arbitration, all over the world. And how do you deal with those practicalities for witnesses and experts sitting in different venues? So that is ultimately what we're talking about when we say a virtual dispute process. Although courts are in the process of adapting procedures and processes to cater for virtual dispute resolution, similar to what I've mentioned above, so which is like the case line that we get in Johannesburg. I think arbitration by its nature is more flexible, innovative, and can adapt quicker to fully conduct virtual proceedings. In doing so, there is the potential of saving costs for parties, although the nature of the disputes does not change by the fact that we're running it virtually. If it's a complex issues in dispute, then the attorneys and counsel will probably still need to take the necessary time to work through the documents, have the relevant meetings to make sure that they properly prepare and present a case before the arbitral tribunal, which is run virtually. The cost savings that we look at probably is from traveling, accommodation, site inspections, venue costs, and also cost for the attorneys, ultimately their time costs in being at the venue before, the day before, and probably the day after. Whether that ultimately makes a virtual dispute more cost effective remains to be seen, but it could most probably be more efficient and ensure disputes are resolved in less time. So are there pitfalls? Like anything in life, yes, there are issues that we need to consider and we need to be cognizant of, in particular when we talk about it from a South African perspective, and again, talking about arbitration. So the first I would say is in particular for domestic arbitrations between two South African parties. The question is whether the Arbitration Act of 1965 actually permits virtual arbitrations. Remember, the arbitrations ultimately are akin to a more or less court process, as the award an arbitrator renders is final and binding and enforceable. The award can be made in order of court through a relatively straightforward court application, and the award can be enforced in the same manner as a court order. So there's important considerations from again, equal treatment and fairness perspective, where we need to ensure that the process is run and conducted properly, and the responsibility for that is ultimately the arbitrator. So going back to the role of the arbitrator and the South African Domestic Arbitration Act, the Act requires the arbitrator to inform every party to arbitration by written notice of the time and the place where the arbitration proceedings will be held. In a typical domestic arbitration clause, the parties would have selected the place of arbitration, and those clauses typically read that the dispute of difference will be referred to arbitration in a particular jurisdiction. So it will have either Johannesburg or Cape Town, with reference to where the place of arbitration will be, and it will be in accordance with the particular rules, the AFSA rules, which arbitration is administered by AFSA, so it's an administered arbitration. So selecting the particular seat or place of arbitration is significant. The question, will that make a difference in the setting where you have a virtual arbitration where the place of arbitration is Johannesburg, but the arbitrators are actually sitting in various jurisdictions or South Africa? So in Cape Town and Durban, the arbitrators are sitting and the parties are all over. Does that have an effect on the process? So if we look at international arbitrations, and in particular the International Arbitration Act, which adopted the model law, the Universal Model Law, there the difference is if the seat of arbitration is, say, London or Paris, for practical reasons and convenience, the arbitration can be held or located anywhere. So the arbitrators can effectively sit in the Seychelles and Mauritius, but the seat of arbitration and the courts that have oversight is still London. So the question is, would we have the same, in particular looking at the old act we currently have for virtual arbitrations, and is there certain restrictions placed on having virtual arbitrations by virtue of the law currently in effect? The other issue, I've mentioned the fundamental importance of arbitration in South Africa conducted on a virtual basis to ensure that equal treatment of parties. The principle of equal treatment is one of the cornerstones of South African law. In that regard, we will need to consider how courts will deal with refusal by parties to participate in arbitrations where certain instances it's practical to conduct a virtual arbitration, and if the parties have agreed to arbitration. When we look at international arbitration and the international law, courts and other jurisdictions where parties have refused to entertain virtual arbitrations, the courts have not really seen that as a ground to ultimately set aside an arbitral award. So these are the legal considerations that parties fundamentally need to take into account also. Not that it's insurmountable, it's important to ensure that once you structure your virtual arbitration, it takes into account all of these legal issues also. The other issues are matters relating to the presentation of evidence, how to preserve the integrity of the process, and when one has a witness that is not physically present with the arbitral tribunal or parties, avoiding witness contamination. So how do you deal with that where a witness sits somewhere in a remote location? How do you avoid contamination where you could easily have access to his cell phone or other means of being contaminated by the party he ultimately is being led as a witness? The other major issue for a virtual dispute resolution or any virtual process is cybersecurity. How to deal with issues such as cybersecurity threats. Having a virtual arbitration, the risk of cybersecurity attacks is real, and it will be important to ensure that proper protocols are in place to mitigate against such risk, to protect the data and the sensitive information of the parties. And that places an important role either on the institution, which is the repository of the information, or ultimately the party or the arbitrator that needs to ensure that the process is run fairly and also the integrity of that process is secured. Issues relating to the technology, reliability of connections, connection speed, ensuring again parties are not able to tamper with connection by manually just switching off the connection and then the arbitration is delayed for whatever reason. So there's a multitude of issues that parties need to consider. Various institutions globally have published guidance notes on how to deal with virtual arbitration proceedings. Institutions such as the ICC, the Chartered Institute of Arbitrators, have issued a comprehensive guide on notes for parties to consider in dealing with the issues that I've just mentioned, either from a domestic law perspective, ensuring that the arbitral award is enforceable if you conduct a virtual arbitration, the other technological issues. So for now, it seems we are in the trial and error phase of testing what works and what does not work for ultimately ensuring that in the using virtual arbitrations or virtual dispute resolution, justice is done to the parties involved in those processes. So the takeaway from my session is virtual arbitrations or dispute resolutions will happen. We need to adapt to the change of ensuring that sufficient checks and balances are put in place that will ensure that arbitral awards are not challenged if it's an arbitration ultimately that you're dealing with. I do not think that we will totally conduct all disputes virtually, but dispute resolution in its traditional sense, where we're talking about physical presence, whether in paper-based or physical hearings, will change, and hopefully to the benefit of the users of dispute resolution services, being the disputing parties. So pursuant to that, I now am going to hand over to Justice David Untitled to take the discussion further in terms of the oversight of the courts and the processes. And just to note again that as part of his discussion, you may ask questions pursuant to his discussion as he needs to leave to a virtual court matter. Thank you.
Yes, thank you. Thank you very much. And thank you for the opportunity to be on this seminar. Last week, I spent 5 days hearing a long and complicated case on a virtual platform. It was the application to certify a class action in the Steinhoff case. And the papers, the papers run to many tens of thousands of pages. There were numbers of large teams of counsel and attorneys, and we ran for 5 days dealing with the matter pretty much as we would have done in a court of law. And I think by the end of the 5 days, at 2 minutes to 4 on Friday, I think everyone felt that the issues had been considered, the questions that needed to be asked were asked. And although we all approach this new world with some circumspection and uncertainty, I think practical efforts to just engage the process are thus far proving to be surprisingly successful. What I want to do in the time that I have available is to address a few of the practical areas that arise in respect of how to deal with cases on virtual platforms. What are the difficulties and what are the opportunities that the platform gives rise to? Now, I suppose if we start the discussion at the highest level of consideration, we are facing a pandemic the world over. It requires that we exercise very great care in terms of congregating together as we did before the lockdown in order to secure our health interests. But it matters equally that those parts of the society that can stay open, and to the extent that that is possible, they should. And access to the courts is a fundamental underpin to the nature of our society. And so courts the world over have been looking in a remarkably short period of time to adapt procedures to ensure that courts can remain open while we respect the ways in which parties are permitted to ensure that fair process takes place within our courts. I think it's fair to say that not every kind of proceeding is equally capable of being dealt with on a virtual platform, and that some proceedings are harder to deal with and more adaptation and circumspection is required. So if we just look at the various forms of court process, for example, I think if you move from the most difficult to accommodate, which is a criminal trial, which not only has participants who are not able often to have access to the virtual platform, but where it may be thought that physical presence is potentially constitutionally important for the purposes of assessing confidential conduct, you may say, well, that's very difficult to replicate on a virtual platform. But if we move out of the criminal sphere, and we may yet overcome some of those difficulties, even in the criminal sphere, a great deal of civil litigation, it seems, is capable of being adapted to the virtual world. And those areas which are most susceptible of replication are obviously motions and appeals which are done on a fixed record. Now, certainly in Gaut, the adoption of case lines has been a simply wonderful and timeless procedure or platform by which you can have all your papers ready to hand in virtual form, and you can access them with enormous speed and facility. So as I've said, for example, in the Steinhoff case, with an enormous record, we were able to navigate it much, much more quickly than we would with a physical hard copy. And therefore, with a fixed record, whether it be in an appeal or in motion matters, as long as you can keep the record on one screen, in the case of case lines, that's extremely easy, and then have your virtual platform on another and move between the two, this really occasions very quick and effective access to the case. It also means that because you don't have to hear evidence, the normal order of legal submission on a virtual platform is readily capable of being facilitated, and I can't see that there is great difficulty in doing so. The civil trial is perhaps a middle line case. I know that, for example, we have already encountered issues around, firstly, access to technology. Now, obviously, for unrepresented parties, the courts have to make provision for the unrepresented, and our courts have already done so in terms of allowing persons to come into court to have access to the virtual platform so that they can use the technology. There is the other question as to people not being familiar with the technology and showing a reluctance to do so. I think if parties have the means, they must use them in order to get familiar with the technology, because it's not the case that one can simply say, I refuse to use it or I won't do so when there is an opportunity to do so. I think we have to recognize that, of course, many features of trial preparation are going to be harder. It's not always clear that being able to prepare witnesses, look at documents and so on is as easily facilitated remotely as it is in a room. But we will have to see whether it is impossible to do that with any efficacy, and thus far I'm not certain that that is so. There may well be certain questions where we have to think about how to show documents, how experts can be consulted, how experts can give their evidence. But thus far, the ability to display documents, to prepare on a documentary record, and to hear evidence and on a virtual platform really doesn't thus far seem to be extensively compromised. One can take matters more slowly. It may well be that one has to adjourn more often to allow for counsel and their attorneys to put their heads together and take instructions where that may be necessary. But whether it be on case lines supplemented with Teams or a similar kind of platform like Zoom, or whether it be that one uses Dropbox and other kindred facilities, I think we are very rapidly getting into a position where even in the midline case of a civil trial, if it's taken carefully and approached sensibly, and almost everything that we thought needed a courtroom can be approximately simulated by using a virtual platform or a number of virtual platforms. I think Jacquel is absolutely correct that while we need, of course, to have access to justice, of course we need to ensure that there is an ability for parties to present their cases and to be entitled to fair proceedings. But what precisely fairness entails, I think, is going to have to be susceptible to some adaptation, because one thing that I think all courts are alive to is the need to ensure that the show goes on. And I think you will probably already observe that many courts in South Africa, being one of them, have taken very quick steps to put in place directives as to how hearings will take place. And as you will have seen from the directives most recently published, when it comes to appeals and to most civil process other than trials, all of that is going to take place often simply with expanded heads of arguments and submissions that are made, with elective virtual platforms being used for oral advocacy. Now, oral advocacy is an important part of our tradition and often extremely effective, but I think what we're going to see is that the need to prepare very full and complete written submissions is going to be at a premium, and oral advocacy is going to be a smaller part of the process and used and more effectively for pinpointing the key issues and developing the key points that are in dispute. So we might become more pointed, use time more effectively, but the show is definitely carrying on. We'll have to see where we go on civil trials. Again, there is going to be every effort to ensure that they do go ahead and that we adapt and use the facilities that we have to ensure that these matters can proceed where at all possible. I do foresee that we're going to have to be flexible, and we will have to take time where it is needed and be alive to the differences that may exist, both as to the type of proceeding and the kind of access that different sorts of parties have to technology. But actually, the world over, if you look at what courts are doing, and if you look at some of the most recent decisions that courts are handing down, you will see that the world over, courts are adapting. They are emphasizing the need to make sure that we facilitate hearings, and they are increasingly wanting to insist that parties must adapt and utilize the courts with the restrictions that virtual courts require, but nevertheless that the ultimate goal, which is the resolution of disputes, cannot simply be brought to a stop by reason of the virus. Courts have very considerable inherent powers to adapt and ensure that procedures work for our present circumstances, and I think that's precisely what courts, our own included, are doing. The arbitration world is somewhat different because, of course, it exists with fewer of the inherent powers that courts have, but there's still very considerable flexibility that is given to arbitrators to make sure that processes work and that they work fairly. They differ from regime to regime, from arbitration agreement to arbitration agreement, but there too, both in international arbitration and domestic arbitration, there are large numbers of arbitrations that are taking place on virtual platforms with the hearing of virtual evidence and the like. And we will start seeing what the challenges are to those regimes. But I think, by and large, the determination to keep the system going is the overwhelming priority that is taking shape in the world as we have it. I think we are going to see aspects of our procedure change forever. The courtroom or the arbitration room will still be there when COVID is long gone, but I think our ability to effectively use technology to make an arbitrable process is much more efficient and effective, I think is a bridge that we have crossed forever. It may, I think, be a good thing in the long run, however much difficulty there is in some of the adaptations and changes that we now have to accept. Let me leave it there, and I'll be happy to take questions. Perhaps Jack will indicate to me, should I just read some of the questions that have come in on the question bar and then try and answer them? Is that how we should go about this? Okay.
Let me pose it to you, and then for all the audience, and then you can answer. I think that will be better. So the first question, there's a specific question that has been addressed to you, and that is, since Caseline has only been rolled out in Gauteng, have the judges been informed on whether the judiciary will now fast-track the implementation of Caseline in other jurisdictions? So that's the first question. David?
Yes, I'm sorry. I think Gauteng was lucky, just that we got case lines going early at the beginning of this year and have been using it very intensively already in motion proceedings. And so we've been able to adapt it quickly for our present circumstances. But I think the determination is going to be to fast track it throughout the jurisdictions of the country, because it is an extremely good program, very easy to use and very, very efficient in virtual hearings. So yes, the determination will be to roll it out over the country as soon as possible.
Okay. Then just a question on fairness. So this is a statement and a question. So on the fairness point and refusal by a party to conduct a hearing virtually, would the lack of technological skills and lack of proper equipment be seen as a reasonable justification for a party to refuse to have a matter conducted virtually, i.e., would it be justifiable for an older practitioner or practitioner in rural areas to argue that he or she does not have the necessary technological skills, support and or equipment to participate effectively virtually? So I think if you can also for now deal with that question.
Yes, of course. So I think it's a question that needs to be divided up into, let me just unmute I think I'm unmuted, to divide itself up into slightly different categories. There's one category of litigant that I've already mentioned, that is either the unrepresented litigant or litigants who are significantly compromised in terms of their ability to get legal representation. Well, their access to courts can't be compromised simply because they don't have the technology and so on to use the virtual platforms, and that's why Gauteng has facilities available. So that's one category of persons. The second category are persons who say, we have the technology, but we simply don't have the ability to learn how to use it. I think the courts will have to pronounce finally on how significant that is as an impediment to fairness. But I think the answer there will probably be that most of these platforms are very easy to use and learn, and to simply refer as a justification for not using the platforms. I think there's a third and different category, which is occurred in other countries, which is where you have perhaps attorneys, counsel and clients who are either in rural areas where there are very weak or no internet connections. Now, I think there one will have to be considerably more flexible. One would have to investigate where is the nearest town, where there are proper facilities, can people move to those places or not. That might be a case where fairness is genuinely a problem. But I do think that it's obvious to everybody that practitioners who adapt and become familiar with the platforms and can use them effectively are going to have a competitive advantage in offering legal services, because this is how legal services are increasingly going to have to be used, and the sooner we all get used to it, the better.
No, definitely, David. I think it's, as you say, it's a case-by-case assessment depending on the type of matter and the parties involved. The other question, there's also a question from that: can arbitration process arbitral institutions assist with the backlog in civil trials and civil applications? Yeah. If yes, how could and should it be done? David?
Well, I think that, the short answer, cases can be probably heard for whatever reason. They are always free to go. That's one answer. But I think the fact of the matter is that the courts, certainly the courts in Gauteng, are responding very quickly, and our court schedules are going ahead. As I say, I spent the whole of last week in a matter. I'm hearing my motions this week, and will be doing so, as will my colleagues, throughout the term. So I would be very surprised there to be any significant backlog of civil process. I'm hopeful that there won't be a backlog. And the kinds of adaptations that the courts are undertaking will also be ones adopted in arbitration. In arbitration, as Jackwell has indicated, there are perhaps issues that will have to be faced as to how far the submission to arbitration permits of these adaptations. But generally speaking, arbitrators have got pretty wide powers to determine process questions, and they will, I'm sure, use and adapt those powers for purposes of facilitating arbitration work as well.
Then, David, just I think the last two questions. So one, will virtual technology make it more difficult for judges to assess credibility of witnesses?
I think that's an enormously interesting question, and the short answer is we will have to see how we go on that. I mean, I think that to some degree the problem is exaggerated because credibility divides into different components. Some of the credibility is simply a question of understanding how a witness has performed in terms of truth-telling, and that is usually a question of seeing how various kinds of answers that are given stack up, and that you can observe as much virtually as you could in a courtroom. There is, of course, the second class of case which deals with demeanor. Now, quite how demeanor plays out in making assessments is one of the kind of mysteries of law, I suppose. But I don't think courts are disabled from making findings in respect to demeanor, because you can observe the witness. You might not be able to observe the witness with quite the same degree of immediacy, but I think that for the most part, credibility in any event is largely determined by the credibility of the answers that are given to questions, and rather less by the somewhat indeterminate features of demeanor that sometimes figure in decisions, but are probably much less important than credibility in the first sense I've described.
Then the last question deals with an appeal. So is an appeal available to a party who feels that a complete virtual process was technically compromised?
I think the answer to that is yes, in the sense that if there has been a procedural failing such that the trial process or the application process wasn't fair, perhaps by reason of some feature of the virtual platform that simply didn't afford parties a proper right to have a fair hearing, then that's a point that can be raised on appeal. I would just offer some caution, which is to say that our notion of fairness is going to be tempered by the times and the fact that there are aspects of our process that both have to adapt and will not be in all respects as good as a hearing in person. But I think you will find courts are going to be cautious about finding that there was a failure of justice because, for example, the process was slower or there was some interruption from time to time with the connection. As long as courts and arbitrators are sensitive to parties and their positions, and the fact that sometimes you have to go more slowly and you have to interrupt to allow instructions to be taken and the like, I think fairness can be done. If courts, ride roughshod over sensible adaptations, well then of course those matters can be raised on appeal, and if courts think intervention is required, they will so order.
David, then there's another question that came in. It's court specific. Do you think the virtual courts will have the negative impact on promoting access to justice, especially for those who are marginalized in society and can't afford data and can't therefore access those virtual courts, and also technological challenges facing the marginalized?
I've sought to emphasize a number of points in my remarks. that we have to be particularly sensitive to the fact that the best kind of virtual court is one that has very significant bandwidth, has got a variety of devices that allow you to navigate successfully across the platforms. That involves cost and investment, and clearly not all. We've got to be very alive to the fact that access to courts is a constitutional principle of great importance. And for those who afford to use the virtual platforms, that is to say unrepresented litigants in particular, the courts must make facilities available, and that's precisely what we have done in Gauteng. You can, if you are an unrepresented litigant, you can go to the court and the platform will be made available to you with assistance to use that platform so that you are not put at a disadvantage. And we've got to use those kinds of mechanisms to make sure that we don't have a two-class legal system where those who have access not only get access to justice and those who don't have compromised justice. That we can't allow.
I think that's the end of the questions and the end of Judge Untitled session. So I just want to thank Judge Untitled for his insight on the court's role in ensuring the show goes on, and ultimately what's being done for virtual dispute resolutions by the court, and their oversight role in respect of arbitrations. So I think I'm going to allow Judge David Untitled just to give a last note of goodbye before he goes to a virtual hearing.
Thank you very much for the opportunity to engage with you, and thank you for the very interesting questions. We are, as they say, on a journey. We have to negotiate it as best we can, but I think the basic message is that both the courts and the arbitration systems are doing pretty well in keeping justice going. So let's carry on in that spirit.
Oh, definitely.
Thank you very much.
We are now going to hand over to Advocate Lyndon Nkosi Thomas to take it forward.
Thank you. Thank you, Jacko. Colleagues, it's a great pleasure to join all of us on this webinar and to share some insights on how COVID-19 has impacted the world of dispute resolution, in particular the world of arbitration. Yesterday, perhaps I should preface my talk about the celebration that we had yesterday. Yesterday, South Africa celebrated a watershed that was brought about by the elections in 1994. It was a watershed indeed, because it brought about a new era, a dispensation of a democratic nature. Now, here we are in 2020. We are experiencing yet another watershed. It is a watershed that has been brought about by COVID-19. The world, colleagues, as we know it, has changed forever. But as the learned Judge Untitled has cautioned us, or has encouraged us, the show must go on. Now, how exactly do we ensure that this show goes on as arbitral practitioners? And this is the purpose of today's webinar. We must, as we continue with this conversation this afternoon, bear in mind our overriding duty as arbitration practitioners, that overriding duty being a duty of dispatching the business of arbitration as expeditiously and as cost effectively as possible. But now, how do we do that in the face of this pandemic? The obvious answer, may I suggest, is that we should resort to in virtual arbitrations. That is the only way to do it. That's how it's happening the world over. The judiciary itself, as we have heard from Justice Untitled, is doing the same. Ladies and gentlemen and colleagues, I have had the pleasure of sitting in a 5-day arbitration last week and sitting in 2 case management conferences. I must share with us that I was encouraged by the uptake of the legal profession and the arbitration sector in particular to virtual arbitration. I found that colleagues are keen and eager not only to learn, but to progress their arbitral matters forward using virtual arbitration measures. Now, if I may divide my talk into 2 aspects, I'll speak about substantive matters that we as arbitral practitioners have to bear in mind as we embark upon this journey of virtual arbitration. And of course, I shall deal with the procedural issues that arise. In relation to the substantive issues, Jackwell has reminded us that fairness is an overriding consideration in arbitral matters. It is an overriding requirement because conducting an arbitration in a manner that negates this virtue or this value renders the arbitral award ultimately susceptible to being set aside. Now, within the context of domestic arbitration, where an arbitrator seized with an arbitration commits or rather violates this value of fairness, that will lend itself to a misconduct within the context or contemplation of the Domestic Arbitration Act of 1965, I think it is. It's antiquated, and one is pleased to note that the Department of Justice is working on a revision of that act. So if one were to violate the value of fairness, then one gets oneself into the trap of a misconduct, which would render the ultimate award reviewable under the Act. And so these are the aspects on the substantive side of the debate within the context of fairness, and that one will have to take into account. An arbitrator conducting her arbitration, I beg your pardon, virtually should steer clear of taking into account evidence that was not put before the arbitrator, refusing to allow valid or relevant evidence to be brought, and some side taking a bribe, delivering a biased award, all those matters, an arbitrator, whether sitting virtually or otherwise, should avoid. Now, another aspect that has to be borne in mind on the substantive side of the debate is the seat-venue dichotomy. It arises because in an international context, one would have a clause, an arbitration clause in the contract, as Jackwell has mentioned before, that assigns Johannesburg, for argument's sake, as the seat of the arbitration. as a locus arbitrary. Now, ordinarily, the seat and the choice of seat determines the procedural law that applies to the arbitration. And what happens in a situation where the arbitrator is hearing an arbitration virtually, sitting in Mauritius, and party A is in London and party C is in Paris? How does that affect the choice of seat and the legal and jurisprudential or juridical consequences, as it were, of the choice of a seat? Happily, the fact that an arbitration is seated in Johannesburg does not prevent the parties to elect a venue at a place other than at the seat of the arbitration. So that presents no difficulties whatsoever. So that happily allows for a situation wherein, whereas the parties would have decided Johannesburg as the arbitral seat, as the locus arbitrary, parties could find a venue for themselves elsewhere. Now that's the distinction between the seat and the venue analysis. Now what about the award? What if this virtual dispute resolution mechanism results in an arbitrator whose arbitration is contractually seated in Johannesburg, publishing the award electronically from Mauritius yet again? These are matters that have been considered before, I have no doubt, but under the model law, the award is deemed to have been made at the seat of the arbitration. So although debates might arise, particularly from a losing party seeking to impugn an otherwise valid award, it would appear to me that this matter should not present any difficulties. If I may now turn, I hope I still have, I'm within my time, not sure how long I've been speaking for. If I may turn now to the procedural aspects of virtual arbitration or dispute resolution. The first, in my experience, the first task of an arbitrator after appointment is to convene a case management conference. Now, I suggested to us earlier on that I've had the pleasure of convening 2 case management conferences last week, and I found that the arbitration community in South Africa is very keen and cooperative in that regard. I don't see why we should not encourage more or virtual case management conferences. Subsequent to a case management conference, with a view, of course, to disrupting as much as possible the pending and current and future arbitral proceedings, I suggest that the arbitral timeline or procedure to be designed at such a CMC case management conference should be as follows. As much as possible should be achieved, I suggest, through documents. In other words, of course, the pleadings will be exchanged at based on an agreed timetable. When preliminary matters arise, as they often do, I find in my arbitration practice that jurisdictional challenges almost always arise. I don't know whether the people listening in have a similar experience, but matters such as jurisdictional challenge, applications to compel discovery, those matters I suggest should be dealt with not virtually even, they should be dealt with on paper, but it becomes a bit challenging when one goes to the evidentiary hearing, because there, and I've noted that which Judge Unterholter had to say about observing the demeanor of a witness. I'm still old school like that. I prefer to see my witnesses and observe their body language as they testify. So when it comes to the evidentiary hearing on the merits, although I would suggest, and that is my practice, that as much as possible should be achieved on paper. And by that I mean the pleadings will be exchanged, of course, electronically on paper, and the witness statements be exchanged. Then I would afford a witness 15 minutes in chief to confirm or amend certain aspects of the witness statement. I find cross-examination to be challenging in terms of putting a cap on time on how long a cross-examiner should be granted, awarded to cross-examine, because one encounters frequently, I must say, evasive and recalcitrant witnesses. So that I find to be a challenge. But the point of it all being that with the evidentiary hearing on the merits, we could employ virtual dispute resolution much more effectively if we stick to the practice of the exchange of witness statements, and we offer very little time to confirm the witness statements in order for the witness statements to stand as evidence in chief, and of course to allow for cross-examination that I'm afraid must happen according in my submission and suggestion, virtually on screen, not desktop, so as to allow the arbitrator to observe the demeanor of the witnesses involved. There are issues of cyber security. The ICC has offered a useful write-up on that, which I would suggest for the parties to have regard to, in order to ensure that the cyber security of any arbitration is not imperiled. And it would be very interesting to see how that plays itself out in practice. And with those remarks, colleagues, I shall then say to us that indeed the show goes on, and as arbitration practitioners, let us do the best we can to uphold our overriding duty to dispatch the business of arbitration as expeditiously and as cost effectively as possible. Thank you, Jacko. Jacko? Jacko?
Hi, everyone. Hi, Lindy. Thank you. I was on mute. We're now going to hand over to Julia Leroux, and she will be dealing with virtual arbitrations from an institutional perspective, specifically as the registrar for AFSA International. So I hand over to Julia.
Thank you, Jacko. Hi, everyone. Good afternoon. Thank you very much, Jacko and the team, to put up this together and giving me this opportunity to speak. As the previous two speakers have said, the show must go on. So as an arbitration institution, as AFSA, what we do is to try and provide a stage or a venue for the show. So we facilitate the arbitrations that must still just go on. And as you might all know, that AFSA is an arbitration institution that administers the arbitration and other alternative dispute resolution. We also act as an appointment body when the parties require us to do so, and so also if the arbitration agreement provides for appointment only or just provides for administration, that's what we do. So we normally facilitate the hearings physically at the EFSA venue or at other alternative venues that parties agree. However, this whole thing has changed by COVID-19, and this virtual hearing might just become a new normal. So as an institution, we also facing different procedural issues such as the venue, the time zone of the parties in the international arbitration, the transcript, recording, interpretation, and how to identify the participants and the tag team, the procedures for taking of evidence, and how to demonstrate the documents, and what electronic hearing bundles the parties should be using, and what platform the documents can be shared. So EFSA we have conducted the online hearings previously, but most of the time it was just for the interlocutory applications, procedural hearings, or case management conferences, or the pre-arbitration meetings, which more or less just for a day. It's not that much of like a 5-day hearing or a whole week hearing. However, the reality that the entire hearing might have to be conducted virtually is what we have to face. So for us, because we only facilitating the hearings, it is still for the tribunal and the parties to consider whether the virtual hearing is possible and acceptable, and whether face-to-face or video conference hearings will suffice. It just has to be decided on a case-by-case basis. For instance, we had the comments from the arbitrators, and we speak to the arbitrators also. The arbitrators sometimes find it tiring to just conduct a 5-day hearing just in front of a computer. But yeah, it just depends on the tribunal and the parties to decide how they would like to conduct the hearing. But as EFSA, as an institution, we are able to provide necessary equipment and software with high quality internet connections, but that was at the venue. So if there are cases when the whole hearing is virtual, so all the parties and the tribunal, they sit at different venues and they just only connect through a platform. But there are also cases, especially in South Africa, with this levels of lockdown become now level 4 or even released further. We might have situations when one party can actually come to sit at the EFSA venue, and the other party or the arbitrator or the witness, they call in on the virtual platform. So in EFSA, we have 2 hearing rooms with big screens that the parties can use. And we have the standard technical support there and assistance, and that is to minimize the chance of signal interruptions or the other technical problems. In terms of the current situation, the EFSA Secretariat has also communicated to the parties that's been using EFSA's service or to the legal fraternities that the new request for arbitration, including pertinent exhibits or the other initial documents, can be filed with the Secretariat in electronic form. We're now encouraging the filing of the request for arbitration and other documents by email. And we just try to mitigate the current difficulties for the submission of hard copies. And we discussed with tribunals how to encourage the parties to use the electronic means of communication for the submissions and the exhibits to the full extent possible. And we also, in discussion with the tribunal and the parties, and we encourage the parties whenever possible to agree to the electronic notification of the award. As for the filing of the documents, EFSA is working on a platform so that we can also have a case line type of platform so that all the documents can be filed together on an online platform. Unfortunately, that platform is not ready yet, so we don't have an existing platform, and we're just encouraging the parties to agree to a common platform. Some parties, they agree to use things like a Dropbox, but sometimes there are specific rules by different law firms that they're not allowed to share a certain online, like Dropbox kind of tool. And in that case, we just encourage using of email, and then we come up with electronic hearing bundle. Currently, we are using Zoom as a preferred hearing platform, but we are also aware of the complaints about the safety and security of Zoom. However, Zoom is also working on it to improve the security protection of the virtual hearing. What we do now is we before the hearing, we circulate the full names and roles of all the participants to a remote proceeding, which would include the tribunal, the legal representatives, the counsel, the parties, witness, and interpersons in advance. And then we strictly adhere to the list. So if there are any new participants, the parties will have to discuss with the other party and the tribunal and the secretariat to add that person onto the list. And obviously, if it is an EFSA administered matter, we will act as the host of the meeting, and we have to admit every participant into that meeting so that we act as a second layer of the security guard, just to make sure that irrelevant persons do not come into the meeting. And also for Zoom, we find that Zoom also gave that tips like you mustn't use the personal meeting ID, and we adhere to certain other methodologies that Zoom is adopting to ensure a secure hearing. In terms of the witness integrity, so not to compromise the evidence when the witness is sitting in other jurisdiction. What we had done previously is if that witness happened to sit in a city or a jurisdiction where we have cooperating institutions, we contact that institution and we arrange for the witness to go sit at that institution using the virtual hearing platform or facilities. And we also ask that institution to send a staff member to act as a neutral, to just observe the whole hearing to ensure that the evidence or the witness statement or the whole cross-examination process is not compromised. So that is also what, as an institution, that we can arrange. The takeaway for this is that it is a learning curve both for a lot of parties that involved in the current arbitration and for EFSA itself. For us, we prepared for ourselves for virtual hearing only by using Zoom. But looking at the current situation and the different options, obviously we are also looking at providing a type of menu for the parties to choose from. Like ICC has integrated this comparison of web conferencing software in the directive. That comparison of web conferencing software gave you tens of different programs. I don't think EFSA will be able to provide like all those programs, but we are very well prepared to accommodate a few major applications such as Zoom, as Microsoft Teams, as WebEx by Cisco, that we are preparing for that. Another thing is we are also trying to put together a practice directive just to supplement those procedures that is not included in the EFSA rules in order to cater the specific needs of virtual hearing. And also we need to publish some online etiquette as the cyber protocol, how to conduct the virtual hearings. So it is definitely a learning curve for all of us, and we are trying as much as possible to facilitate a very smooth hearing and just to have a seamless operation in these difficult times and in the foreseeable future. Thank you very much. I'll give it back to Jackal. Thank you.
Thank you, Julia. Very useful and informative from an institutional perspective. I'm now going to go to the specific questions that has been posed, and I'm going to start. There's quite a few questions that we've gotten in, and also some of the other questions that overflow from the previous or the earlier questions raised for Justice Untitled. The first question I think I'm going to address to Advocate Nkosi Thomas SC, and that question is, in her virtual arbitration hearing, did she get an opportunity to cross-examine a witness? If so, what was her experience?
Thank you. Thanks, Jackal. I was sitting as an arbitrator, and we used the Zoom platform, and yes, witnesses were cross-examined during that arbitration. And as I said, I'm old school. I believe in watching the demeanor of witnesses, particularly under cross-examination, and I found that it worked. It worked very well. I could observe the demeanor of the witnesses, the body language, and I could hear them clearly. Where a witness became uncomfortable and they reached for a glass of water, or they wanted an adjournment to recompose, gain composure because the questions had become very difficult. I could observe all of that. So in a nutshell, it worked well, very well indeed. Thank you, Jackal. Back to you, Jackal.
Thank you. Then the next question would be, it's a technological question, and it deals with what is currently the most effective electronic medium virtual platform to be used for a hearing? Is it Microsoft Teams, Zoom, or other? And which platform is best for the document exchange and document viewing? And I think I'm going to ask Julia to deal with that question, and I can also interject at the end. Julia?
Thank you, Jackal. What we are using currently is Zoom, and I personally find it very easy to use. I've also just getting more familiar with Microsoft Teams, and the comparison that I could research online shows that a lot of people say Microsoft Teams is more secure than Zoom. But Zoom, for me, is very handy because it's just very easy. Even if for someone who is not so tech savvy, you just gave them a link, and it's they can even just join a meeting through the web. They don't have to download anything. So that for arbitration hearings, I sometimes find it useful, because the parties, or especially the witness, or sometimes the representatives, they haven't been exposed that much to technology side. So if I explain to them how Zoom works, it normally just takes me like one email. I just send an email to say how it works, and I haven't had any real technical problem that people come back to me to ask, I can't log on, or I can't come, or whatever. And we obviously always try to set up a trial run before the hearing time to make sure that everyone is on the same platform. And in terms of the document sharing and viewing, we had a hearing 2 days ago when the parties, obviously, they have agreed to an electronic bundle, and they each have that electronic bundle on their computer, and they could just share screen. Was the Zoom platform offer that share screen? I know Microsoft Teams as well. To use the share screen tool, you can actually put that page of the documents on the screen with everyone, and you can highlight that whichever part that you want to bring people's attention. And that went very smoothly, I have to say. But I'm sure Jekyll and Lindy, they have used other platforms, and they probably know the other platforms better. Thank you.
Thank you, Julia. Yeah, just I think from my side, if you look at different virtual platforms, from a CDH perspective, we use primarily Microsoft Teams. But when I engage with other colleagues, whether in South Africa or in other jurisdictions, it's usually also through Zoom, and a lot of other law firms find Zoom more secure. And I know Zoom is busy working on increasing the security and cybersecurity issues. But if you look at also the ICC, and you've pointed it out, the ICC and CIR has issued some guidance. So no institution will endorse a particular platform. So they would say you can use WebEx, you can use Microsoft Teams, and so on, and you need to do your own research. And it's ultimately for the party. So when you agree on the arbitration process, you will agree as part of the specification which platform you'll use, the connectivity to the platform, and also how you will deal with the exchange of bundles, how you will deal. So on Microsoft Teams and Zoom, you can actually create separate virtual rooms. So you have the arbitration room or mediation room, and you have separate virtual breakaway rooms also, which both I think Zoom and Microsoft Teams support. So it's ultimately, from a technological perspective, it will still progress, but it's ultimately up to the parties as part of the process to agree on what platform from a technical perspective suits their needs and the accessibility of that. So, and from a document exchange perspective, so ultimately, if you're running the entire arbitration virtually, you will probably create a central repository either through OneDrive, ShareDrive, or other platforms, and you can use that to share documents during the arbitration process. And then again, attached to that is your Microsoft Teams or Zoom platform, where you will ultimately share your document to the participants during the arbitration or virtual hearing. So yes, there's no specific recommendation in relation to that. Then I'm going to go to another question, and maybe Lindy can also come in here. So the question deals with technology. What will technological difficulties such as connectivity issues or equipment failures during the hearing have on cost, chargeable, recoverable by the arbitrators or counsel, i.e. this bears consideration where the hearing takes longer than planned as a result of technological difficulties? Lindy?
Yeah, that's a very interesting question, that because the question seems to suggest that it's a vis majeur situation, as it were. So who should bear the cost occasioned by that which is not attributable to either of the parties appearing before one? I think that question should be answered on the basis of the general rule, shouldn't it? That the costs follow the event. It will be part of the costs that will be, payable by the party that would have lost before one. But perhaps one must add that even though there might be a technological failure that results in time wastage, as it were, ultimately, and when one looks at the arbitral proceedings overall, I'm confident that the parties are going to find that running arbitrations virtually will decimate the costs of arbitration, and to a point that technological failure, the cost occasioned by that technological failure, will pale in significance when one has regard to the saving that would have occurred thanks to virtual arbitration. I mean, it simply saves travel costs, time, opportunity cost. A whole lot of saving accrues to such a process thanks to virtual arbitration. Thank you, Jaco.
Thank you, Lindy. And then just my 2 cents also. So if you look at, so again, some of the institutions have issued directive, and in particular, if you look at the ICC and when they talk about technology. So again, it's important for parties before starting the process to agree on the type of technology, the connectivity, bandwidth, and all of those other incidentals. So what they actually recommend, if you look at some of the guidance notes, and I'm just going to read. So they propose you do mock sessions, you look at the connectivity, you agree on the connectivity, and then ultimately, if parties do not comply with those requirements, then the arbitrator probably has a discretion in relation to the issues of cost. If you can justifiably and objectively indicate that it's because of the party that you didn't have the necessary connectivity. But yes, there are ways to try and mitigate that. And to deal with it. So the next question, we have 5 minutes left. There's quite a few questions that has come through. Another question, which I think is important, and I'm going to ask again Lindy, because it's more from an arbitrator perspective. An arbitrator is essentially in control of the process and procedure in an arbitration. How can he or she ensure the integrity of oral evidence presented by a witness in circumstances where the witness will be in an uncontrolled and remote environment?
Yes. Well, that's a very interesting question. But when we're talking about the integrity of the evidence, I take it the question refers to a witness perhaps not referring to documents that are not before the arbitrator or something like that. No, Julia referred to look, I have not dealt with a situation such as that, and I'm thinking on my feet now, but Julia referred to someone at a foreign jurisdiction or at a remote location performing a function, as it were, of watching over people that are in the room to ensure that the number of people that are in the room as communicated to the arbitrator matches what is actually happening at that remote location. Julia, if I didn't understand you correctly, I'm sure you will correct me. But we will have to develop these practices as we go along. That matter did not arise at all in my arbitration of last week. Neither did that issue arise at all in any of the 2 case management conferences that I conducted last week. But all the people that had joined me, we used Zoom in all the instances. I had their names on screen, and I could see them for myself on screen. But in terms of underhanded dealings at such a remote venue, I stand to be guided as this journey of ours progresses. I hope that's helpful. That's as best as I can offer.
That's good enough. No, thank you, Lindy. I think we appreciate that. We're all still learning,
Yes.
and the processes, and we're going to go through a few bumps as we go along, but
Sure.
ultimately we'll get it right. We've come to the end of the session. There's a few other questions, but we are at the end of the session. And I just want to thank the audience firstly for allowing us to ultimately go into your house and be with you and discuss this interesting topic. And then I also want to thank all the presenters for informative session on each of the issues from an arbitrator's perspective, institution, and also Judge Untitled. So thank you very much. We really appreciate your attendance and presenting to the audience. Thank you.
Thank you. Thank you, Jaco and team. Thank you very much for having us.
Thank you very much. Thank you.
Pleasure.
Thanks for having us, Jacqueline.